So welcome back, ladies and gentlemen. The sixth session will focus on confidence building, preventive diplomacy, and dispute resolution. And we are pleased to have Mr. Robert Harris, Assistant Legal Advisor for Asia and Pacific Affairs, United States Department of State. So Mr. Harris, you have the floor. Thank you.
Thank you very much. I would also like to thank the Diplomatic Academy for Vietnam to once again presenting a state-of-the-art workshop, and everything has been done to perfection, and we're very grateful for all your efforts. I think at this point we are turning our discussion sort of back in our last three sessions to talk about the actual disputes in the South China Sea. For the last panel we talked about geostrategic competition, but I think this will be a turn back to what caused this conference to exist in the first place, which are territorial and maritime disputes, which are unresolved. Could you keep it? Yes, territorial and maritime disputes which are unresolved, and what steps the parties and others might productively take to help address those, either to resolve them or during the pendency of resolution, try to manage the disputes. So that is our topic for session 6, confidence building, preventative diplomacy, and dispute resolution. We will start with Professor Carl Thayer, and I will welcome him to the podium.
Thank you, Rob. The shoe's on the other foot. I now have to finish in 12 minutes itself. And I'm hoping that this is my outline, but in brevity, I'm going to go because the points are there. This has been covered to death, so it's going to be a series of shots that take us from the beginning. 1992, when China gave a Crestone company a concession in the Vanguard Reef area, and ASEAN issued its first statement of concern, and bring us right up to the present. The second, 1995, occupation of Mischief Reef. We're back where we began because of the Repsol case in that same area in 2017, 2018. Very little known. We had, as a result of the occupation of Mischief Reef, a Philippine initiative in ASEAN to come up with a code of conduct. March 2000, the two sides exchanged those codes, and I have copies. They're only 3.5 pages long each. But they couldn't agree on the geographic scope, and we heard that plenty in my particular panel. We had this exchange, and then that led 2 years later to the Declaration of Conduct, a non-binding agreement that's the foundation. We moved from that to the terms of reference for an ASEAN-China Joint Working Group, 2004. And then what happened is the guidelines went through 20-odd revisions, and the only change was point 1, where ASEAN wanted to meet as a group and present a unified front to China. And in the end, they folded, and they only decided to promote dialogue. So the guidelines to implement that made it a 10+1 arrangement. Then we have an agreement by ASEAN on the proposed elements of the Code of Conduct in 2012, before the ill-fated summit in Cambodia, where lack of consensus prevented a joint statement. But Marty Natalegawa from Indonesia did a shuttle diplomacy and got everybody on the line, and we got the principles on the South China Sea that the Cambodian foreign minister's ASEAN chair had to read. We then had an ASEAN consensus on the principles, and then we began to move up at the end of the arrow into final action on hotlines between Ministry of Foreign Affairs, the Code for Unplanned Encounters at Sea. 2017, a short framework, preamble, general understandings, conclusions, then a single draft negotiating text, which is agreed by all, and then working towards a final code of conduct. And latest intel is that China says it's complicated, take 1, 2, 3 years, I'm hearing. The single draft text itself is a compilation of not 11 but 9 members. Laos and Myanmar say nothing. They don't exist in this. And what this table shows you, there are 216 separate proposals to be dealt with. The first column indicates 81 of them, which ones were submitted by individual countries. The next, they have support. 2, 4, 5 countries have agreed on particular points. 12 minutes, I can't summarize all of that. But the key in the guts of paragraph 2C in the middle of the following areas, and I deal with them: the duty to cooperate, Bob Beckman and everybody else that quotes his lordship, practical measures, take measures of a practical nature under the law and protect the environment of a semi-enclosed sea. That's straight there. Promotion of practical maritime cooperations. We have options submitted by Philippines, a joint Indonesia, Singapore, then we have China, and then Cambodia's own special one. But when you read the Code of Conduct and you have the 4 alternatives, when you get to the end, you have Vietnam's submission that says, replace it with ours. And Vietnam has 2 parts. One are cooperation, which cuts over the same area, and it's detailed. That would be good, and so does China. So there's a basis there. But Vietnam has 7 do nots. Do not resort to force or coercive actions, cruel, inhumane, or degrading treatment and punishment against persons from the states. Don't construct on any artificial island. Don't complicate or escalate the dispute. Don't militarize the features. Don't blockade vessels carrying supply. Don't declare an air defense identification zone. And don't conduct simulated attacks by aiming guns, etc., at ships itself. That's tough. Self-restraint and promotion of confidence. Indonesia, these are standard dialogues: humane treatment, voluntary notification of military exercise, exchange of relevant information. China has one, China, the Philippines has one, and China, those should be omitted. Option 2, it includes all those countries making separate proposals, exchanges between military port calls, the standard confidence building measures that we have. But here on China's option 2, this is important. The parties shall not hold joint military exercise with countries from outside the region unless the parties concerned are notified beforehand and express no objection. Now, they are putting words in China's mouth. That's a China veto. Simple. Whatever they want to say. We have China and the Philippines, just humane treatment. That's the fishermen. And the Philippines to restrict traditional fishing rights. So it's not only China that can claim traditional fishing rights, but the arbitral tribunal said around Scarborough Shoal that was traditional. Prevention of incidents. We have 8 countries making 7 proposals, and these are all, for nautical people, for those in the audience unfamiliar, these are the alphabet soup of collisions against regulations, saving a life at sea, search and rescue, etc., etc., the international conventions of civil aviation, the International Maritime Organization, and protocols for self-restraint. Brunei suggests that the Maritime Fund be used to promote English language training so all the naval officers can speak the same language with each other. I'd say everybody should also learn to speak Chinese and have a liaison officer. Early harvest measures and promote incidents. So these are that. Management, 8 countries, 11 proposals. Indonesia played a very strong to comply with all these international regulations, so it's repeating. And hotlines, and now the ministry, but they burrow down military, civilian, Coast Guard, and other agencies. These are all proposed. A lot of homework will be involved in doing that, and procedures to manage incidents, and how to monitor. And here the differences are. Those are Brunei, Cambodia, China, Malaysia, and Singapore. Those are 1, 2, 3, 4, 5. As an example of multilateral support. ASEAN senior officials should be tasked with doing it. Vietnam suggests the foreign ministers or their representatives, which could be senior officials, to monitor itself. So let me get into key issues for resolution. Geographic scope and dispute. We heard it this morning. Parasols doesn't belong. There is no definition. Vietnam has a very detailed one. It should be your territorial sea, your exclusive economic zone, and your continental shelf. But we don't define the South China Sea itself. And the parties should respect the exclusive economic zone, continental shelves. But Malaysia and Singapore suggested be defined. My suggestion, they all but Laos and Cambodia belong to the International Hydrographical Organization, and it defines the South China Sea from northern Taiwan down the coast of China and Vietnam and the Philippines to the mouths of the Gulf of Malacca. So why not take that? They all belong to the organization. But we heard from earlier today that the parasol shouldn't be included. So geographic scope must be defined. The tough one is going to be military activities. About notification of activities and whether a party has a veto, which I've already met. notifying on a voluntary basis, so that could cause some problems if you don't notify, and notificate as Vietnam is saying, give us 60 days notice, but we don't need anybody's approval, we'll carry them out. Cooperation among maritime law enforcement, these repeat, and China has very detailed and very positive ones in the fishing area, capacity building, and joint exercises. There are some substance there, hotlines. An extension of queues to Coast Guard type agencies we know is under discussion, but that needs to be done. But they need to be operational in guidelines and protocols, and in the draft we can have an agreement, but you could see extensive protocols and guidelines in each of the following areas worked out as it progresses. That will take some time to do. Dispute resolution, 2 proposals. Since China has acceded to the Treaty of Amity and Cooperation, it has on a voluntary basis that's where you take your disputes. Bob Beckman and other lawyers here, what Vietnam does is take it straight out of the UN Charter. When you have a dispute, you go through friendly negotiations, require mediation, conciliation. Vietnam follows that path and then says, and of course, the Treaty of Amity and Cooperation, but that's voluntary. But nonetheless, that's in accord with international law. We get to the legal status. First, Vietnam proposes that all can't have, at the bottom, no one can have any reservations when they sign, and they consent to be bound by it. What Vietnam proposes is that the national legislatures of every country ratify it. The National People's Congress of China, the Quốc hội, the Vietnam National Assembly. You deposit those instruments with the ASEAN Secretary General, who becomes a depository, and he goes to the UN under Article 133 and gives them to the UN Secretary General. Whether these are legally binding treaties, we could argue about itself. What is the role of third parties? At the very beginning of the document, the preambular section, Vietnam contributed definitions to almost all the key terms, and third parties are not signatory, and there is no reference about accession by third parties. Brunei proposed a biannual resolution to the UN General Assembly. My argument would be the dialogue partners of ASEAN should be a party to it, and China can't say they're external parties. They sail, they operate in the South China Sea themselves. So with that, I end my presentation, and I've given hopefully some time. I'll speak in Vietnamese. My students call me Violin Thayer, that's machine gun Thayer, because I speak it tat 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 tat. So you had a machine gun Thayer presentation. Thank you.
I think history has just been made that a presenter actually finished with time left on the clock, so we should revel in this moment. We will go to our next speaker, and we'll deal with another aspect of this, which is crisis management at sea, and I'd like to turn the floor to Lieutenant General Nguyen Quang Dam.
Trước hết thì tôi xin chào mừng các vị đại biểu có mặt và cảm ơn ban tổ chức đã cho phép tôi trình bày một cái chủ đề như là một sự mong muốn, đó là Biển Đông ổn định hơn, hòa bình hơn, thông qua cái đề xuất để chúng ta cùng nhau thảo luận về các biện pháp quản lý khủng hoảng ở Biển Đông. Đi vào vấn đề này thì chúng tôi đặt vấn đề vị trí chiến lược và nguồn tài nguyên phong phú ở Biển Đông đã làm phát sinh nảy nở nhiều vấn đề phức tạp, nhạy cảm và khó lường. Từ đó khu vực này đã chứng kiến sự tương tác giữa quan điểm và nhu cầu lợi ích khác nhau của các quốc gia ở Biển Đông và quốc gia ngoài Biển Đông. Tác động đó là rất lớn, trở thành mối quan tâm của cả thế giới, và Biển Đông trở thành vùng nóng ở khu vực, thậm chí là vùng nóng ở trên quốc tế được quan tâm. Vấn đề thứ hai là nghiên cứu những khía cạnh liên quan đến Biển Đông thì cho thấy sự phức tạp và tương lai rất khó khăn cho việc ổn định, hòa bình và phát triển ở khu vực này. Sự khó khăn ấy xuất phát từ việc mục đích khai thác địa chính trị ở Biển Đông của các quốc gia như thế nào. Biết rằng ổn định lâu dài ở Biển Đông là một tương lai xa và chưa có hồi kết, nhưng không phải là không có giải pháp cho việc kiềm chế khủng hoảng ở đây. Vấn đề thứ ba là thời gian gần đây thì chúng ta cũng đã thấy xuất hiện những cái tín hiệu rất là tốt để phấn đấu cho một Biển Đông ổn định do cái sự nỗ lực của các bên liên quan và chung tay của cộng đồng quốc tế. Như vậy là khả năng kiểm soát khủng hoảng ở Biển Đông được ổn định cơ bản lâu dài là có cơ sở hiện thực. Nếu như các quốc gia có lợi ích ở đây, chúng ta tuân thủ theo những quy định của luật pháp quốc tế và có sự thống nhất với nhau. Từ vấn đề đó thì chúng tôi cũng đề xuất những cái giải pháp mà chúng ta để nghiên cứu và thảo luận. Thứ nhất là chúng ta nên thống nhất nhận thức chung về thực trạng đang quản lý ở Biển Đông như thế nào và đã có những cơ sở pháp lý gì ở Biển Đông. Thực trạng ở Biển Đông là sở hữu của nhiều quốc gia. Và trong khi Công ước Luật Biển năm 82 đã tạo ra một khung pháp lý để quản lý hoạt động ở Biển Đông theo một nguyên tắc chung, đó là đảm bảo sự công bằng, hòa bình và bền vững, thì diễn biến ở Biển Đông lại có những vấn đề ngược lại. Đó là có những quốc gia yêu sách cái chủ quyền tài phán của mình theo một cái pháp lý riêng. Mặt khác là có quốc gia đòi hỏi chủ quyền đã vượt qua cái khung pháp lý mà Công ước Luật Biển quy định, có tính chất áp đặt nên những cái nảy sinh rắc rối khó đoán định, để từ đó đẩy Biển Đông vào một cuộc tranh chấp pháp lý và phát sinh những phức tạp khác, làm cho Biển Đông mất ổn định. Một hiện trạng nữa là thực tế ở Biển Đông thì còn tồn tại nhiều khu vực chưa được phân định, chưa hình thành những ranh giới phù hợp mà luật pháp quốc tế và quốc gia liên quan chấp nhận. Ở Biển Đông cũng chưa thống nhất được những văn kiện pháp lý quốc tế để các quốc gia ở khu vực cùng nhau hợp tác nhằm khai thác bền vững, ổn định, bảo tồn và sử dụng lâu dài tài nguyên biển. Nên đã có quốc gia tùy tiện tuyên bố hay hành xử theo yêu sách riêng của mình. Do đó, xét về mặt bản chất, yêu sách đòi hỏi và cách hành xử có tính áp đặt đã tạo lên những cái điểm nóng ở Biển Đông. Một yếu tố nữa đó là do cấu tạo tài nguyên sinh vật và không sinh vật ở Biển Đông, như là tính di cư của thủy sản, rồi cấu tạo trầm tích khoáng sản vắt ngang, và những vấn đề an ninh phi truyền thống như là an ninh hàng hải, rồi tội phạm xuyên quốc gia, cứu hộ cứu nạn, bảo vệ môi trường. Nó đòi hỏi các quốc gia phải ngay lập tức cần có những khung pháp lý để hợp tác giải quyết, mà chúng ta không thể chờ đến có những cái thỏa thuận pháp lý về phân định chủ quyền thì lúc ấy mới giải quyết. Do vậy mà để giải quyết khủng hoảng vì một Biển Đông hòa bình ổn định thì các quốc gia có lợi ích ở đây, trước hết là Trung Quốc và ASEAN, cần phải nhìn thẳng vào thực trạng khách quan ở đây, chủ động tích cực từ điều chỉnh những cái yêu sách của mình, đồng thời là cùng nhau hợp tác để hoàn chỉnh cái khung pháp lý ở Biển Đông có tính tạm thời nhưng rất thực tiễn trong giai đoạn này, trước khi đi đến một thỏa thuận cuối cùng, tránh cái việc dùng sức mạnh để giải quyết khủng hoảng. Hiện nay ASEAN và Trung Quốc đang xúc tiến COC. Đây được coi như là một bước đột phá, như là một văn bản pháp lý tạm thời để đáp ứng những cái yêu cầu mà thực trạng như chúng tôi phân tích ở trên. Một giải pháp thứ hai đó là xây dựng lòng tin chiến lược. Chúng ta bàn nhiều về vấn đề này, và xây dựng lòng tin lẫn nhau trong hợp tác là việc làm không mới. Nhưng mà đối với Biển Đông thì tôi cho rằng là tư duy này cần được quan tâm và phát triển mạnh mẽ. Khi đã có sự tin nhau thì chắc chắn sẽ đi đến những cái giải pháp làm cho Biển Đông hạ nhiệt, giảm căng thẳng về chính trị, về ngoại giao, kiểm soát được những va chạm. Chúng ta có thể xây dựng Biển Đông từ một khu vực xung đột trở thành một khu vực hợp tác. Con đường này có thể chông gai, nhưng nếu xuất phát từ xây dựng lòng tin thì chính lòng tin sẽ trở thành cái chìa khóa để mở cơ hội các quốc gia ngồi lại với nhau để cùng nhau hợp tác. Căng thẳng ở Biển Đông bùng phát hơn một thập kỷ qua đã làm xói mòn lòng tin chính trị. Mọi sáng kiến, mọi biện pháp ứng xử dễ bị nghi ngờ và cảnh giác. Điểm ngại đó chúng tôi cho rằng là có cơ sở, bởi vì đã có những yêu sách có tính chất áp đặt để biện minh cho một cái vùng rộng lớn, bất chấp quyền lợi chính đáng hợp pháp của các quốc gia có liên quan. Do vậy xây dựng lòng tin ở đây cần có những cái nội dung cụ thể, có nhiều nội dung, sau này các diễn giả khác sẽ trình bày, nhưng mà tôi quan tâm đến hai cái nội dung. Cái thứ nhất là các quốc gia phải tự điều chỉnh những yêu sách của mình cho phù hợp với luật pháp và thông lệ quốc tế, tránh tuyên bố có tính chất áp đặt hoặc thách thức làm xói mòn lòng tin. Cái thứ hai là phải chấm dứt những hành xử trên biển bằng sức mạnh, hoặc là những cái hành xử mà làm cho các quốc gia khác lo lắng, nghi ngại, nghi ngờ. Đây là những cái mà chúng ta quan tâm. Một cái giải pháp thứ ba mà chúng tôi đề xuất đó là chúng ta phải quản lý tranh chấp. Chúng ta cũng phải thừa nhận một cách khách quan là Biển Đông là một biển chung, nhưng là đang có sự chồng lớn phức tạp và có tranh chấp. Nghiên cứu vấn đề pháp lý ở đây là khá gay gắt, trong khi diễn biến ở Biển Đông lại cho thấy một cái giải pháp căn bản về phân định vùng biển giữa Trung Quốc với các quốc gia khác ở Biển Đông là rất khó khăn và lâu dài. Vì thực trạng quản lý và cơ sở pháp lý ở đây là không được tôn trọng. Những yêu sách vừa có tính áp đặt, vừa có tính mập mờ về bản chất, là cái hố sâu ngăn cách để đi đến một sự đồng thuận. Khủng hoảng ở Biển Đông trong suốt thời gian qua được xuất phát từ 3 cái tranh chấp. Thứ nhất là tranh chấp của chủ quyền, thứ hai là tranh chấp liên quan đến quyền tài phán giữa các vùng biển liền kề, cái thứ ba là tranh chấp đến kiểm soát ở Biển Đông. Như vậy là các loại tranh chấp trên được xuất phát từ sự tính toán giữa lợi ích dân tộc với lợi ích chính đáng cả các quốc gia có liên quan, giữa yêu sách có tính chất áp đặt với cơ sở pháp lý và những giải thích khách quan về thực trạng ở Biển Đông. Điều đó đã va chạm trực tiếp đến lợi ích, đến chủ quyền, quyền tài phán của các quốc gia khác ở Biển Đông và các quốc gia có lợi ích ở Biển Đông, ví dụ như là Mỹ hay là Nhật. Để quản lý cái tranh chấp này thì các quốc gia có lợi ích ở Biển Đông phải tự cam kết và chủ động hội nhập ở 4 cái lĩnh vực. Thứ nhất là phải xây dựng được cái lòng tin chiến lược. Cái thứ hai phải tôn trọng cái thực trạng biển, thu hẹp cái yêu sách của mình cho nó phù hợp với cái quy định của Công ước Luật Biển năm 82, mở rộng các lĩnh vực hợp tác phát triển, trong đó cả cái vấn đề hợp tác về an ninh biển, chung tay và thống nhất xây dựng COC, một văn bản pháp lý cân bằng lợi ích của các bên có liên quan. Vấn đề tiếp theo tôi xin trình bày đó là cái giải pháp hợp tác khai thác ở Biển Đông. Như phân tích ở trên thì cho ta thấy là cái hợp tác toàn diện ASEAN và Trung Quốc để giải quyết vấn đề Biển Đông. Trong đó hợp tác cùng khai thác ở Biển Đông là một xu hướng lịch sử và thời đại, là biện pháp tích cực hữu hiệu để quản lý khủng hoảng và tạo dựng lòng tin giữa các bên ở trong cái quản lý ở Biển Đông. Trong khi căng thẳng ở Biển Đông được xuất phát từ sự xung đột chủ quyền, lợi ích và đe dọa hòa bình an ninh khu vực, thì chúng tôi cho rằng là Biển Đông ví như một vùng biển là để chia sẻ lợi ích giữa các bên liên quan. Nhưng với vai trò của Biển Đông thì nhiều người cho rằng nếu mà chúng ta phát huy được quan điểm hợp tác và cùng phát triển thì Biển Đông sẽ trở thành một biển gắn kết với nhau, gắn kết giữa các quốc gia với nhau. Các quốc gia đang xung đột lợi ích ở đây có thể là xích lại gần nhau hơn. Do vậy hợp tác cùng khai thác ở đây được xem như là một xu thế được lựa chọn trong lúc này. Định hướng về hợp tác ở Biển Đông nó phải thể hiện, thứ nhất là hợp tác phải đem lại cái lợi ích chung và cân bằng cho tất cả những cái bên liên quan ở Biển Đông. Hợp tác ở những vấn đề cụ thể, tạm thời né tránh những cái yêu sách mà cực đoan mà rất là khó giải quyết. Cái thứ ba là phải xây dựng một cơ chế hợp tác chung lâu dài cho cả khu vực. Cái giải pháp cuối cùng đó là hợp tác trong quản lý và bảo vệ an ninh ở Biển Đông. Hiện nay các quốc gia ở đây đang có những cái biện pháp về hợp tác về hải quân rồi về cảnh sát biển nhằm tạo ra cái niềm tin chiến lược. Chúng tôi cho rằng đây là bước đi đúng. Một khi Biển Đông leo thang căng thẳng thì việc xây dựng tiềm lực quốc phòng an ninh ở đây không được tôn trọng và đã được các quốc gia đưa lên hàng đầu. Chính vấn đề đó sẽ đi đến một cái cuộc khủng hoảng và một cuộc chạy đua vũ trang ở khu vực. Điều đó để đối phó với những cái khu vực và những thách thức đó thì các quốc gia ở ASEAN cũng như Trung Quốc đã có những cái bước đi để giảm bớt căng thẳng, đó là tăng cường hợp tác về an ninh biển. Các hoạt động ở trên biển chúng tôi cho rằng là nếu có xảy ra xung đột thì cũng từ những cái lực lượng hải quân, quân sự hoặc là lực lượng cảnh sát biển. Chính vì vậy sự hợp tác của các lực lượng bảo vệ biển sẽ là một kênh quan trọng, nó như là một trụ cột để mà kiềm chế bùng phát xung đột. Sự hợp tác này thể hiện ở nhiều kênh, nhiều hình thức với nhiều góc độ lĩnh vực hợp tác khác nhau. Ví dụ như là trong các diễn đàn an ninh khu vực thì chúng ta cũng cần phải đánh giá một cách thực chất và đề xuất những biện pháp hiệu quả về quản lý an ninh biển ở đây. Cái thứ hai là các lực lượng bảo vệ biển, nhất là lực lượng cảnh sát biển các nước ấy, phải phối hợp và thống nhất với nhau những đối sách xử lý, làm sao mà chúng ta có thể chấp nhận được. Ví dụ như vấn đề nghề cá chẳng hạn, hiện nay thì các nước ASEAN hay là một số nước thì có những cái hành xử nó cũng còn khác nhau. Thế thì cái việc thống nhất những cái đối sách ở trên biển, tôi cho là những cái biện pháp tạo dựng lòng tin rất là tốt. Cái thứ ba là chúng ta thiết lập cái kênh thông tin để giải quyết những vấn đề an ninh phi truyền thống, những vấn đề môi trường, những vấn đề tai nạn ở trên biển. Thì vấn đề này đã và đang được làm, nhưng mà cần phải đẩy mạnh và hiệu quả hơn. Ví dụ như là trung tâm IFC ở Singapore, rồi RECAP ở Singapore về cái trung tâm thông tin chống cướp biển, cướp có vũ trang ở khu vực châu Á. Một cái biện pháp nữa là chúng ta phải tổ chức diễn tập, trao đổi kinh nghiệm và hỗ trợ nâng cao năng lực xử lý ở trên biển. Cái này cũng là một cái giải pháp rất cụ thể để cho những lực lượng hải quân, lực lượng an ninh biển chúng ta có cơ hội tiếp xúc với nhau để nâng cao cái sự hiểu biết và tôn trọng, tránh cái chuyện va chạm ở trên biển. Cuối cùng là tăng cường các hoạt động tuần tra chung. Hiện nay kênh này thì cũng đang được khuyến khích và đã triển khai ở những cái nước song phương. Tôi cho rằng đây là một cái hoạt động có tính chất hợp tác, có tính chất thị uy, nhưng lại có tính chất răn đe đối với tội phạm và chúng ta rất là quan tâm. Có thể kết luận lại là cái bài tham luận của tôi là cho rằng là cái chiến lược, những cái căng thẳng mà mang tính chiến lược ở Biển Đông đã tác động sâu sắc đến hòa bình ổn định ở khu vực. Nguyên nhân sâu xa và bài học sâu sắc nhất vẫn là vấn đề chủ quyền và lợi ích chiến lược Biển Đông. Những quan điểm có tính chất áp đặt về chủ quyền đã tạo ra sự bế tắc trong giải quyết nhiều vấn đề có liên quan. Từ đó đã giảm đi lòng tin chiến lược, khó khăn trong hợp tác, cảnh giác trong quan hệ, phát sinh những khủng hoảng. Tuy nhiên là nếu mà chúng ta dũng cảm nhìn thẳng vào thực tế khách quan, kiềm chế những yêu sách cực đoan, phát huy những cái tương đồng thì chúng ta sẽ hợp tác tốt hơn. Và vùng biển Đông không phải là một vùng biển chia rẽ nữa, mà nó trở thành một cái vùng biển gắn kết với nhau và cùng phát triển. Cái bài phát biểu của tôi kết thúc ở đây. Xin cảm ơn hội nghị.
We'll next turn to different issues of resources. As I think all of you know, the Law of the Sea Convention in Articles 74 and 83 provide that during the pendency of a maritime boundary delimitation, the parties are strongly encouraged to enter into provisional arrangements of a practical nature. Professor Jacqueline Espenilla will discuss some of those issues, particularly through the prism of discussions and issues relating to the Philippines and China in thinking through joint resource development.
The joint development of hydrocarbon resources is a familiar concept to many of you. Its most succinct definition is, as you can see, found in or enunciated by the tribunal in the Guyana versus Suriname arbitration. Usually, it's undertaken between two or more parties that have unresolved, overlapping, or potentially legitimate claims to an EEZ or continental shelf where hydrocarbon resources are located. Its main characteristic and also its rationale is that sovereign issues are provisionally set aside for the purpose of maximizing mutual economic benefit. And as was already mentioned by Robert, the legal basis is found in UNCLOS. And it provides the legal basis in the sense that it is treated simply as a provisional arrangement of a practical nature, the assumption being that the parties will someday come to a final agreement. Now, all of this is to say, so far, is only to establish that joint development is that in a vacuum. But we cannot leave it there, because the very value of joint development is transformed by the context in which it is sought to be applied. The specific context I referred to is the Philippines-China context. Is there still merit for these two countries to pursue or work on negotiating such an agreement? It's been widely reported that Philippines and China are in talks to enter into a JDA. And honestly, there's not much information that's publicly available. But what has been established so far are very uncertain. But first, it's clear that there is no agreement yet. And second, parties are in no rush to negotiate precisely because such an arrangement is very complex, and possibly also due to the fact that the very idea itself is very unpopular in the Philippines. Joint Development Zone has also not been finalized, and however, if you look at news reports, it has been mentioned time and time again that it is being considered for the Reed Bank, an entirely submerged reef which is part of the Philippine continental shelf. With the arbitral decision, the fundamental premise of joint development is no longer present. The existence of potentially overlapping claims is no longer there. China has no entitlements to the area under UNCLOS. So why do a JD still? Why potentially risk giving tacit credence to China's claims? We can theorize two possible reasons: the political aspect and economic aspect. The political aspect is this. The Philippines-China relationship is obviously a complex one. While there is a desire to protect sovereign rights, we also do not want to escalate tensions. A JDA may be seen as a strategic act of preventive diplomacy meant to address tensions and distrust relating to unresolved issues following arbitration. In practical terms, the Philippines needs to ensure two things. First, mutual restraint. A formal JDA can serve to prevent future confrontations in the proposed JD zone, since the arrangement requires parties to exercise a degree of such restraint in order for the venture to be successful, the very reason why such an arrangement was entered into the first place. It would not serve the interest of either party to insist on very rigid, hardline confrontational positions. Second, confidence in the Philippines-China relationship will be promoted. Confidence, after all, is built on transparency and predictability. A JDA might deliver both. It can yield real benefits which might significantly allay domestic fears and concerns, which again, frankly, in the Philippines are very high. Second, the economic aspect. The Philippines right now draws much of its energy or power generation requirements from the Malampayan natural gas field, and it currently fulfills most of Luzon's power generation requirements. However, this energy resource is due to run out soon, so thus Philippines is on the clock to find an alternative source of energy. Failure to do so means that the Philippines will have to import natural gas at tremendous cost, which obviously is not good for the economy. Thus, a China-Philippines JDA might make practical sense. And of course, it's also unconfirmed that the SES is estimated to hold about 11 billion barrels of oil and 190 trillion cubic feet of natural gas, a good portion of which supposedly is found in the Reed Bank. The area, of course, has not yet been explored or exploited. The Philippines tried to actually pre-arbitration, but it was met with Chinese diplomatic protest. And to avoid further issues, the Philippines has since suspended all deep-water oil exploration activities. Now, insofar as the economic aspect, the JDA could possibly achieve three things. First, it could buffer against a future energy crisis by providing an alternative source of energy. Two, it could provide some measure of political and legal certainty for investors. Three, it could be a concrete way to benefit from China's expertise in resource exploration exploitation. Moreover, it could also help safeguard resources against the inefficient and inequitable exploitation of the party that's more capable of doing so unilaterally. In American oil industry parlance, it could be considered as averting the application of the law of capture, the unilateral exploitation by one party to drain the resource and in so doing lay claim to the entire resource to the detriment of the other party, which may also potentially stand to claim the same resource. Thus, a JDA could be considered as a defensive position. In this sense, if you formally negotiate it, obviously you could build in more safeguards to such an agreement, such as, for example, subjecting the area to thorough mapping and baseline accounting, which could possibly allow for protection against one party's loss of the resource. Now, everything mentioned so far are just potential benefits. They are unlikely to be realized if certain legal pitfalls and challenges are not addressed. Of course, when we speak of legal pitfalls and political challenges, the big elephant in the room is the arbitral award. It clarified many issues, but the bottom line is that China does not have entitlements in the area. Thus, the legally appropriate approach for the Philippines is to treat the JDA, any JDA in the future, as a form of political accommodation and insist on a well-crafted without prejudice clause. A clause that reserves the right both to maintain their claims even as both set it aside for the purpose of realizing economic benefits. But what is also not widely reported in international media is that there are domestic legal constraints as well. The Philippine Constitution presents the most significant barrier. Okay, that's read back. The Philippine Constitution presents the most significant legal barrier. As we know, the Philippine Constitution is fiercely possessive of the country's patrimony. Specific provisions of this document, as well as Supreme Court pronouncements, establish the following. First, all natural resources are owned by the state and cannot be alienated. Second, exploration, development, and of natural resources shall be under the full control and supervision of the state. Third, the state may undertake exploration, development, and utilization either by itself or by co-production, joint venture, or production sharing with Filipinos or, and I emphasize this, Filipino corporations, at least 60% of which capital is owned by Filipinos. But for large-scale explorations, the same activities may be, the President of the Philippines may authorize the same activities to be done in agreement with foreign corporations, even up to 100% owned foreign corporations. But however, the emphasis here is that these are basically service contracts with the foreign corp acting merely as a contractor and the government as still the owner. The government still exercises active control. All of this to say is that the Constitution and its various interpretations do not contemplate JDA as it is understood in international law. JDA between states under the Philippine Constitutions is conceptually prohibited over the continental shelf. Also, we dig a little deeper and show that there is in fact also contradictions with the JDA concept and the Philippines Oil Exploration and Development Act, which sets up our country's service contract system. Basically, what it does is that it's only concerned with commercial arrangements which don't contemplate sharing ownership and control with a sovereign power. All of this together indicate that the idea of JDA is conceptually prohibited. And that, together with the arbitral award, makes it very difficult to move forward with the idea in the first place. Thus, if the Philippine government does intend to pursue JDA with China, it will automatically be subject to intense legal and political scrutiny, calling into question, ultimately, whether or not it will take off the ground. JDAs, therefore, are like a crossroads of sorts. They can be beneficial if done in a legally and politically appropriate way, but again, for the Philippines and China context, that may be quite difficult. And also, on the other hand, failure to act and still proceeding can actually provide more reasons for conflict between the two countries. Now, linking back to the theme of this panel, the effects on multilateral cooperation efforts. ASEAN and China have been trying to define its relationship for the longest time, witness the long road that we have been taking to a final and binding COC, as well as other cooperative efforts that are running in parallel. What the region is really trying to do is to build an infrastructure for sustainable peace. The infrastructure for peace concept obviously has been used in domestic post-conflict situations, but may find application in this particular situation. The basic premise is that sustainable peace can be achieved if certain building blocks are in place in order to prevent the relapse into tensions or violence. The idea is that you take apart one issue of conflict and tension, and then rather than approaching it as one issue, you take it apart and break it down into various elements. JDAs can be one such building block, and if they are, for example, if it is, for example, concluded in a legally and politically acceptable way, I submit that it can become a very influential part of this regional peace infrastructure. Okay, put it there. So my conclusions are pretty straightforward. A joint development in a vacuum is good. However, it is very futile to insist on a joint development in general as a solution. The theory underpinning this arrangement is crystal clear. However, what is important to realize is that context is key and the devil is in the details. The Philippines-China relationship faces tough legal and political hurdles. Hence, it's very important to maximize the caution call that's right now being advocated by many sectors. Failure to address these issues at the earliest stage obviates the various potential benefits of what, in theory, is actually a very good idea. However, if they are addressed, a Philippines and China JDA might become part of a regional peace infrastructure, which might have spillover benefits to other parallel cooperation conversations that are happening right now, such as in the negotiation of a COC and other what I would think of as more low-hanging fruit in terms of cooperation. So in that sense, it has to be approached from this analytical manner and not just apply wholesale the concept of joint development to the Philippines. Thank you.
Thank you. And to close our speakers, we will have Ambassador Sothirak, who will talk about confidence building and preventative diplomacy in the South China Sea region, I think with a focus on ASEAN.
Thank you, Chair. Good morning. First, I'd like to begin by extending my appreciation to the organizers, particularly my good friend, Dr. Tung, President of DVA, for including me in this very interesting, and I have learned a lot so far. So I'm hoping to share some of my thoughts on a topic that was given to me, mainly dispute settlement mechanism, the ASEAN style. If I have time, I will talk about small other things like how ASEAN can manage US-China rivalry, strategic rivalry, and maybe add a little bit more on how the COC can be sensibly achieved. So let me go on with the ASEAN dispute settlement mechanism. No one can dispute ASEAN good intention in its pursuit of a peaceful, secure, and stable region as stipulated in the ASEAN chapter. However, implementation of the ASEAN dispute settlement mechanism remain more of the aspirations than a reality. ASEAN member states still need to promote greater acceptance of the enforcement of the rule of law, be it international or domestic law, and encourage their government to adopt a more open and positive attitude toward various modalities for the settlement of dispute rather than just focusing on negotiations. In managing dispute, ASEAN has produced various dispute settlement mechanisms through different legal instruments such as the ASEAN Charter, the Treaty of Amity and Cooperation in Southeast Asia, the ASEAN Protocol on Enhanced Dispute Settlement Mechanism, and the Protocol of ASEAN Charter on Dispute Mechanism. Despite these mechanisms, ASEAN must confront or still lacking concrete action and serious commitment to put these instruments into proper operations so as to be able to resolve any dispute that may arise between and among states inside and outside ASEAN. ASEAN must overcome the implicit agreement that members of the association cannot meddle in one another's affair, not to mention the limitations of capacity and resource. ASEAN state-centric principles should be recalibrated to allow the operationalizations of the DSM framework to bring about acceptable outcome and to address the following challenge, which include some recommendation in there. ASEAN Charter have not been institutionalized satisfactorily and legally empower ASEAN to have effective mechanism to settle dispute. Article 22 to 28 of the Chapter 7 of ASEAN Charter still have constraints and need to be empowered with legal capacity to settle the dispute between states. In the case of non-compliance by any AMS with the finding, recommendation, or decisions resulting from the ASEAN dispute settlement mechanism, any affected AMS means ASEAN member state, may refer the matter to the summit for decision, may refer to the summit, as stipulated in Article 27 of the chapter. Again, ASEAN summit are political forums with political interests for effective conflicts resolution. These disputes sometimes should not refer to the so-called political platform. Consensus norm allow AMS to act in its own interest rather than in regional common interest. The case of ASEAN's failure to produce a joint communique in 2012, we hear again and again, to resolve the differences in the case in the South China Sea dispute, is one example, but the PCA, the Permanent Court of Arbitrations, more recent time also is another example. Although the 1976 TAC covered all dispute between states in Southeast Asia as well as any Southeast Asian state with the state outside of Southeast Asia region which have acceded to the TAC and none have the dispute with ASEAN in Southeast Asia, but mutual consent is needed to bring the dispute to the High Council, which will form by the ministerial representative from the 10 ASEAN member states, and that the High Council must hear the dispute case, which must be serious and disruptive to regional peace and harmony. Under these conditions, the South China Sea dispute can fall under TAC, but China would never agree to refer the dispute to the High Council. Without China consent, there is no mutual consent for the dispute to go to the High Council. Similarly, regarding the bilateral border disputes such as one between Cambodia and Thailand over the piece of land, precisely 4.6 square kilometer piece of land surrounding the temple prairie here, without Thailand consensus, the case cannot be referred to TAC High Council. Here, the principle of non-interference in Thailand domestic affairs has neutralized Article 22nd and 23rd of Chapter 7 of ASEAN Charter. This case is a clear demonstration that internal political affairs prevail over ASEAN legal instruments which impede on positive image and credibility of ASEAN to make the dispute settlement mechanism more effective. And I can go on, and if those of you want to revisit the basic principle of ASEAN dispute settlement, please refer to my paper, quite long. Now let me talk a little bit about, I still have about 5 minutes. I want to talk about the ASEAN role in managing strategic rivalry between US and China. During the span of half a century, more than now 52 years, ASEAN has been aspiring to preserve peace, stability, and prosperity among all 10 ASEAN countries and cultivate healthy relations with all dialogue partners. However, ASEAN relevance is constantly confronted with a multitude of emerging serious security issues in recent time. Chiefly among them is the ability to manage and resolve strategic rivalry between US and China. China's rise is seen as becoming a competition to the predominant or preeminent American in the world stage. And America, the pivot now, Indo-Pacific, although the shape and form Indo-Pacific strategy that is described in the US NSS release late last year, have been seen as to contain China, although Washington keeps saying it is not so, but I don't think China believes that is the case. So these set stage for a big competition between ASEAN and China. So as the US and China push and shove each other in order to extend their sphere of influence in the region, countries of Southeast Asia are increasingly drawn into this complexity of this global power play and have to absorb the tedious heat of frictions between those two powers in many more years to come. If ASEAN can act together, it will be difficult, in my view, for US and China to impose its will over the whole of Asia region, and I have some point to make here. ASEAN should continue to try to engage US and China through its existing framework, even if there is a limitation of what ASEAN can do. There is little ASEAN can do to overcome the geopolitical and ideological drive and differences between these two big powers. However, it is not entirely without leverage. Washington and Beijing are keen to court ASEAN and to pay some consideration to its wish when framing their principle and policy. How much clout can ASEAN do in this regard depend on ASEAN's ability to forge unity and centrality. Hence, there is a need to seriously push forward the EAS process and the implementation of the ASEAN Community Vision 2025 and the ASEAN Political Security Community Blueprint 2025. Increased competition between the two powers is not entirely bad news for ASEAN, provided it remains within certain limits. ASEAN can take advantage of its by effectively hedge between the two powers to secure maximum benefit, but such hedging game on one power against the other, there's limit and danger. When competition gets out of hand, it could hurt us Southeast Asia and it may force ASEAN to take side. Full-blown conflicts between major powers will be the worst outcome because it could destroy ASEAN-based security architecture. ASEAN needs to define its own leadership. To do otherwise is to cede the initiative on outside power. The largest state ASEAN in terms of size and influence, for instance, Indonesia, should consider offering that leadership and assume a position as a smart captain for the ASEAN chairmanship to navigate through this complex and uncertain geostrategic environment. ASEAN principle of neutrality must not constrain ASEAN's sphere of action to work out suitable security arrangements that can lead to a reduction of tensions caused by US-China power competition. ASEAN should make it clear that Southeast Asia is nobody's backyard to impose anything that is harmful to the common regional interests. Otherwise, ASEAN position remain narrow and over-dependent on a single player. ASEAN must unify its stand not to take sides in the US-China power rivalry and need to continue to engage both powers constructively in projecting ASEAN's continued aspiration for peace and prosperity in the region. I'm right on time, although I have one last point to make, but please read my paper. In my view, how we can go about getting the COC to formalize with the interest of everybody involved. Thank you very much for your attention.
Thank you. So we will open up the floor to questions. So maybe what I'll do is I'll just start in that direction and move across, and then we'll probably take about 3 at a time and then give a chance for the floor to proceed. So starting over in this end, are there any questions as we go? And there'll be another chance to come back. Yes.
Thank you. Excellent presentations. I wonder whether we could just ask a very basic question, though, which is if we were to get to the end of the rainbow and have a code of conduct actually agreed upon, under what conditions or how would you measure the effectiveness in terms of protecting ASEAN member states' sovereignty? That is, what would be the practical enforcement and implementation that would protect the Philippines or Vietnam or other ASEAN members from the kind of encroachments or militarization or other big power actions that might be taken by a big neighbor? And so what exactly is the Code of Conduct going to do for the Philippines, Vietnam, and other ASEAN members if it were agreed to suddenly?
Okay. Yes.
One question for Dr. Espenilla. You mentioned rightly that that the legal basis of joint development can be found in Article 74, Paragraph 3 and 83, Paragraph 3 of UNCLOS. And I think that in the case of the Philippines and China, the Philippines should be very careful not to include this in the agreement, because there are, the article provides about provisional practical arrangements pending the delimitation of the exclusive economic zone and the continental shelf. But in the South China Sea, my understanding is that there are no exclusive economic zones overlapping in the area between the Philippines and China. So that's the first point. The second point is, do you think that given that China has undertaken most of the exploratory operations in the region, gives this deal an asymmetric imbalance in favor of China in terms of the information held by each party? Because seismic studies and other exploratory operations carried out by China have yielded important information on the oil and gas potentials of the areas. So perhaps China might use that to strike a better deal in the much expected joint development agreement.
That actually was 3, so we can keep focus on the questions that are asked. We'll come back, but why don't we tackle those first 3 questions first, and maybe we'll start, Jacqueline, since that was the most recently asked.
All right. Thank you for your questions. So insofar as the danger of referencing UNCLOS, those specific UNCLOS provisions to a JDA, I fully agree with you, because if we just look at it black letter text, it does pertain to provisional arrangements. And as I mentioned during my presentation, I fully agree that with the arbitral decision, there are no longer any areas under question insofar as this is concerned, which is why even though this is the legal basis for the general concept of joint development, any joint development between these two countries moving forward will have to take a departure from this, in that it must be considered as a political accommodation. Therefore, strictly speaking, it's not according to this, but was inspired by this. And as a result, you can build certain safeguards in, as I mentioned, a no prejudice clause. But again, I fully concur and I share your apprehensions about the danger of even entering into this agreement in the first place. But if assuming that it is within the wisdom of my country's government to decide to pursue it anyway, we have to approach it from how best we can insulate it from further conflict. And then with respect to your second question about whether or not the deal would be asymmetric, given that China obviously would have had the greater capacity and the opportunity to develop or to gather information about the resources in question, I agree with you. Certainly, there is no question that they are, in fact, in the better position to provide that information. But my counter-argument to that is, regardless of whether or not we enter into a joint development agreement, such asymmetric information will be there and can be exploited still. By putting it in the context or the framework of a limiting joint development agreement, at some point, in order for them to be able to exploit it within the confines of the agreement, they have to put that information on the table. To the degree that they will, that's up for debate. But the fact of the matter is, it is the best way to limit or to process that information, because otherwise, they'd still have it and we would have no access to it. Thank you.
I would just note that this is one of the challenges in all these kind of confidence-building measures, is that we still have unresolved territorial and maritime disputes. And the fact that those exist and that countries have national positions that they want to protect very much will always be in the background to steps that countries take in trying to manage the disputes. And that's why lawyers will never be without work. Because there are those kinds of issues that our governments are going to want to make sure that they don't inadvertently suggest that there's a dispute when they don't believe that there is one, or that certain countries have rights that they don't believe that they enjoy. So this is a problem that infects pretty much all of these kinds of confidence-building measures that countries will just have to keep an eye on and resolve. That would take us then to our next question about how would ASEAN countries take measures to ensure that a code of conduct does not inadvertently reduce their freedom of action or their sovereign rights to take particular actions, or just an embracing foreign policy that they can engage in. So I don't know, why don't we start going down the table this way, and anyone who has anything to suggest might add it.
So with Patrick Cronin, I have to start off with a big yes, we'll accept your proposition as the starting point. The draft contains just numerous things, and if we just start off, who's causing the problems? Well, we know in maritime law enforcement agencies, we've had that documented. We have problems with the fishermen and illegal fishing, but attacks on. We have confrontations between military ships and then aircraft, not just, I'm talking of Philippine aircraft being accosted by China. So the code of conduct would end up with extraordinarily detailed protocols and guidelines attached to it. I mean, you know, you're smiling, but I'm saying you say that they reach a code of conduct and they're to respect each other. They have very detailed suggestions already for how to report incidents, from videoing evidence and recording time and place, to be able to take a complaint and to try to have it resolved between the disputants, and then take it up to a dispute settlement mechanism if they can't get an agreement. So in other words, they're looking at the casual encounters. Now if they extended the queues to Coast Guards, so in each one of these areas, the operation of Coast Guards could see liaison officers in each other's ships and greater coordination. As I mentioned before, a dense network of hotlines. And so you could immediately report any transgression. And then there's a long list that's put in there of video evidencing, time, place, bridge reports, whether the protocols were now, what kind of communications occurred to establish the speed, the direction, and the intent of other ships. Very, very detailed, and this is the work of the practitioners that sail the seas. And likewise on the treatment of fishermen and whose waters are they. So in other words, it starts out with respect for the maritime zones. I have to take that as a given, and it's problematic, but you asked me, say, if they have the code of conduct, what could we do? Great protocols on the military ships, and they borrow all the way from international law that covers any of the activities we could possibly think of that are offensive and that cause damage. So it does have that mechanism which is built up over time, which would be routine, that countries would refrain from intervening in the sovereign jurisdiction of other states, and if those incidents occurred, detailed reporting mechanisms, detailed way of taking it up and having outside members look at that and make an adjudication to stop it from happening again. And it would only work on a case-by-case basis as people got more confident in that process. So, and it's to guide behavior and not solve sovereignty and restrict the operations in non-disputed areas that are recognized once the code has been agreed.
Thank you. General Dam?
Về câu hỏi liên quan đến COC, làm thế nào để mà đạt được hiệu quả và liên quan đến chủ quyền của các quốc gia ASEAN, thì tôi cho rằng là COC là một cái giải pháp cần thiết. Nó là một cái văn bản pháp lý tạm thời, và chắc chắn là một văn bản pháp lý thì nó phải có những cái ràng buộc nhất định, và trong COC thì sẽ được giải quyết vấn đề này một cách công bằng và cũng tránh một cách cư xử có tính độc đoán ở đây. Bởi COC đang thảo luận, cho nên là cái mục đích nó đạt được sẽ là như vậy, hy vọng nó là như vậy. Còn vấn đề là các lập trường riêng ở các quốc gia ASEAN thì đúng là ở Biển Đông, chính cái tính bất ổn là cũng xuất phát từ cái sự tương tác giữa quan điểm và lợi ích của các quốc gia liên quan. Vấn đề ở đây là cái lập trường ấy nó có độc đoán hay không? Cái thứ hai là nó có phù hợp với Công ước Luật Biển hay không? Cái thứ ba là cái lập trường ấy có mong muốn giải quyết thông qua cái Công ước Luật Biển hay không? Hay là chúng ta lại cứ lấy quyền lịch sử, ví dụ như thế. Cho nên là cái lập trường riêng ấy tôi cho rằng là chúng ta cũng có những cái giải pháp để mà làm sao mà chúng ta, như tôi nêu đấy, một trong cái giải pháp mà để hạn chế khủng hoảng ở Biển Đông ấy là những cái lập trường nào mà có tính độc đoán ấy, thì chúng ta cũng phải tự điều chỉnh để làm sao nó tiến dần đến những cái thông lệ, những cái quy định của Công ước Luật Biển. Mà Công ước Luật Biển thì nhiều diễn giả đã nêu rồi, đó là một cái công ước là nó rất là minh bạch và nó yêu cầu mọi người phải chấp hành, không có ngoại lệ, một cái công ước hòa bình. Tôi có ý kiến như vậy.
Thank you. Although the question was specifically asked with regard to how COC can protect Vietnam and Philippines, I like to broaden a little bit more because Cambodia is member of ASEAN. But first, let me once again express my. I want to put the COC in its proper context. I don't believe that the COC can solve the claim, whether it's territorial claim or maritime claim in the South China Sea. And when you said protection ASEAN against what? ASEAN really want to have peace and stability, and seeing this code as a way to manage tension or low tension and manage conflict should and if and when it's arrived. That's about all. No more, no less. How you can achieve that? Very simple. How you make the dispute settlement mechanism, the compliance aspects of it can be clearly stated. Enforcement aspect have to be clearly stated in that. And with regard to legally binding, this is a very, very difficult issue that Professor Carl Thayer have listed 216 proposals. So I don't know when we have 10 years before the DOC come into force. I don't know how many more years the COC can come into force, legally, I mean, realistically speaking. So to me, the short answer to your question is that you can make COC as effective as you can make ASEAN and China to agree on basic principle on how to go forward. Thank you.
Thank you. So more questions? Yes.
My question is also to Dr. Espenilla. In this recent proposal or blueprint from the CSIS in Washington, they have a blueprint for joint development of hydrocarbon resources.
Sorry, could you speak louder?
In the recent blueprints published by the CSIS in Washington, they have a comprehensive proposal for joint development of hydrocarbon resources. But it separates between the commercial side and the jurisdictional side. So it proposes to set up joint ventures between state companies and with the right for all the countries around the South China Sea to invest in those companies, but there will be a separate company for the coastal zone or the continental shelf of each state. And China would then, with its financial resources, be able to take major stakes in such joint ventures and would therefore also gain much of the profits. But in this proposal, on the jurisdictional side, it's a condition that they will operate under the jurisdiction of the coastal state. It could be under non-prejudicial clause for any delimitation, but it would be under the jurisdiction of the coastal state, in this case the Philippines. And then also the coastal state would be the only one that had the right to tax it. I think that if the Philippines enter into joint development without having jurisdiction on its own continental shelf and without having the sole right to taxation, it does not only undermine its own sovereign rights, but it also creates a dangerous precedent for the rest of the world. Thank you.
Why don't we?
I guess that I'm giving you a comment rather than a question. But we're talking about the COC, and I think that the COC should be seen in the confidence building measure context. And it seems to me that the process of negotiating the COC and the contents of the COC itself are not really helping to the confidence building measure process. The negotiation of the COC is covered by the air of secrecy. That is really not helpful. Secondly, the contents of the COC is not really going into the substantial matters that includes the legality binding nature of the COC, the geographical scope coverage of the COC, and the enforcement of COC. So I think that we have the problem here if the COC, with the contents and the way it is negotiated is not addressing the points that I have just mentioned. It is really not helping the confidence building. Parties may turn out to be more suspicious of each other than confident of each other. Thanks.
Other questions? I'm sorry, someone in the back, yes.
Thank you very much. May I have one remark and one question? In my opinion, the root cause of the tension in the South China Sea is the efforts to change the sea legal order in the South China Sea. So my remark is that the most important preventive measure is to make joint efforts to maintain, to respect, and to comply with the sea legal order in the region. And I also have one question that I'm very impressed by the idea of Lieutenant General Nguyen Quang relating to the framework for the cooperation in the region. Is it possible that we may establish the regional agreement on the protection of the fish resources in the region? And also, is it possible that we may have a regional agreement on the protection of marine environment and ecosystem in the region? Thank you.
And one more.
Thank you all for the very good presentation. I'm happy to come to the positive side of the world. So confidence building always brings us hope. But I do have a question for Ambassador Sojima. And I think the confidence building involves a lot of countries, but since everyone's talking about China, so for your experience, I understand you know very well about the United States and know well about China, and certainly you represent very well about ASEAN.
So that it's hard to hear.
Sure. So the question,
Too much echo.
okay, very simply the question, being a diplomatic career and also academic, what's your view on what might be considered as the best approach to engage China in the confidence building context? Thank you.
Sorry, the best approach that China can do what?
Engage China in confidence building.
To engage China, sort of okay. So let's address these in turn. There was an initial question about the CSIS study, their blueprint for joint development, and whether you've thoughts on that. So why don't we do that first, and then we'll move on.
All right. So I should first preface my answer by saying that, as is well known, there are many forms of joint development. There is no uniform notion of how a joint development should look like. As a CSIS study does recognize, it's possible that only one country, the coastal state, can in fact be the one to manage all the operations and things like that. Very similar to the Bahrain-Saudi Arabia agreement. It's also very possible that you create a sui generis institutional framework, very similar to what happened between Australia and Timor-Leste. It's also very possible to divide it up into areas where you can have joint ventures managing specifically that area, and within that joint venture area, the country to which that company or corporation pertains to will have sovereign jurisdiction, similar to South Korea and Japan. All of this to say that it's very clear that there is danger to adhering to one and just applying this particular form to the Philippines-China situation. I agree with you, it can be a dangerous precedent if we approach it from that manner. However, knowing that in mind, knowing that and juxtaposing that with Philippine domestic laws, wherein it's very clear that the Philippines would have to have ownership and control, and national laws of the Philippines would have to apply, it's more, I think the road forward will be a little clearer in that the Philippines will have to adhere to this idea. It cannot just give up control just like that, because that's what other forms of joint development looks like in other parts of the world. So insofar as the CSIS proposal, I think the cautionary tale or the cautionary reminder there is that it's better, of course, if the Philippines as a coastal state maintains control, but I don't know how far that can be sold to China. So I think certain accommodations have to be made, but always having the legal limitations of the Philippines in mind. Thank you.
I'd like to put a footnote on that. The timing for the CSI report was slightly just after the leaked release of the single draft negotiating text. China has extensive details of the kinds of cooperation, but specifically on hydrocarbon, China's proposal says it should only be between Chinese and the oil companies of regional countries. No one from outside the region. Doesn't say anything about pre-existing ones. Malaysia's proposal says we are a sovereign state. We will negotiate our hydrocarbon exploration with anywhere that we prefer. I just add that as a footnote to the discussion. Yeah.
I think that goes with a number of comments that we've heard about the code of conduct itself, and it's something we've heard echoed about the hope that it would be conducted in a transparent way. And I would simply, I don't know that that's a question as much as an observation, but we can record that observation was made. And then I guess going to Nong Hong's question about, is your question how can the ASEANs most effectively reach out and work with China on confidence building measures? I wasn't quite sure if that was your question and to whom you were addressing it.
My question goes to Ambassador because I think he can speak on behalf, he knows very well about China, knows well about United States and also ASEAN. So my question is what he consider as the best approach to engage China in a context of confidence building.
Thank you very much for the question. I think I really appreciate this question. I think that throughout the whole conference, we try to deal with China. Nowadays, when China speak or anything to do with China, people pay attention to it. Some positive, some negative. More negative than positive, I must say. One thing that I don't think anybody can stop China rise. How we do about it is to engage China in ASEAN framework of it's true, Tung mentioned that COC is another CBM. All ASEAN can do is CBM. We cannot do PD, we cannot do a dispute mechanism. If you carefully read my paper, we're not graduated from confidence building measure. So what is it to do? Here's some point. First for China. I think China need to recalibrate what its term core interest. Exactly, clearly say what is it that you want your core interest to be preserved. Is it the 9-dash line? Precisely with the South China Sea, is it the 9-dash line? But you never declared, you never really register your claim based on exactly the coordinate of this 9-dash line, which make other claimant very, you don't really know what to deal with it. There's a claim. A claim is a claim until proven is yours, still a claim. But you claim everything. So I think you need to really look into recalibrating your core interests on the South China Sea. For ASEAN, very simple, and it's very difficult. ASEAN need to have unity. ASEAN need to enforce its centrality. Centrality is not about gatekeeping. It's not about fixing agenda. What is it that's supposed to be discussed at the summit? To me, ASEAN centrality is the ability to manage and supervise whatever ASEAN already push out in terms of framework to be effective and can really deliver results. Do a checklist, and I guarantee you that below 50%, I don't have exactly, but I venture to bet with everybody. If you do a checklist, what is it ASEAN achieve? It's below, to me, it's still below standard. But I also want to include the US and other major power, because we relies on these, ASEAN rely on all dialogue partners to keep this region peaceful. So US and other major power, including Japan, Australia, Korea, and so on, to support ASEAN dispute settlement mechanism, and to say we will support you, do more, rather than send a warship to the South China Sea, for example. Recently, I read a news that even UK and France send sort of like warship to the South China Sea. I wonder why. And China are not very happy with it. This is not, it's not useful for confidence building measure. You said that, yeah, China is an aggressor, but if you poke China, they become aggressor. So you have to find a way to also take China's security interest at hand. But to a point that China also have to see other regional interests as well. And I think China is willing to adapt. If you engage China rightly, sorry to use this word, very confused, rightly. But this is a hard thing to do. I'm a diplomat by training. I believe in seductions rather than confrontation. Thank you.
That's fine. I think we have 11 and a half minutes left in this session, and there's a lot of people who haven't had a chance to ask questions. So what I think we'll do is, why don't we, on ourselves, keep all of our answers to 30 seconds or less, and we'll try to see how many more questions we can accomplish. So 30 seconds or less.
One is to take up China's offer in the single draft negotiating text to take the 5 areas of cooperation, and China suggests 3 working groups to cover marine, environmental, pollution, search and rescue, safety and navigation, etc. So there's a way out. Take up that offer and work on it technically. It's in the suggested code.
And I would just note on fishing cooperation that no one here had a paper on that, but it has been identified as one of those areas where there could be contributions that would make a real-world impact, that would both be confidence-building measure and help solve a real-world problem. So I think that has emerged from this session, and I would just memorialize that without having any more conversation on it. But why don't we have more questions, and we will have quick questions and quick answers in our remaining 10 minutes. Yes?
I believe this discussion about the confidence building, one of the main features is the joint development topic, and in a way it refers always between any claimant country in ASEAN with China. My question to any relevant speaker, is there any exploration, any possibilities or any actions involving between one claimant country with the other claimant countries within ASEAN? Because I personally believe we could do something that is also could contribute to this positive atmosphere to settle this challenge issue between ASEAN and China. So when we talk about the joint development,
at that point, is that your question? Because I'm mindful that we're running out of time. But if that is, then we'll go ask a couple more questions.
As long as they got the point of my questions.
Thank you. Other questions? Yes.
Just a very quick question to Ambassador Sothirak. I think that the ASEAN purpose is not just maintain the peace and stability. It's just peace and stability. So we should give women our rights and our entitlements. To gain that. So how do you think that the way that the ASEAN also have to protect? The rule-based order and also other things, the rights and entitlements of the small state, the member states as well, because it's very important to the perspective of small and medium country in the region. Thank you.
And yes.
Thanks. Brett Blackshaw from the U.S. Department of State. I had a question about the code of conduct. U.S. has been a consistent supporter of an effective and meaningful code of conduct, as well as other peaceful means to address the disputes. We are concerned to learn, though, that China has been pressing for ASEAN country agreement behind closed doors to restrict with which partners they can conduct military exercises and with which foreign oil and gas firms they can pursue resource exploration. In our view, where our concern comes from the view that these proposals would restrict the ability of ASEAN nations to conduct sovereign, independent foreign policy, and they would undercut the interests of the United States and others in the international community. We remain confident these far-reaching proposals are unlikely to get agreed to, but they do raise troubling questions about intent. And my question, perhaps for Professor Thayer and Ambassador Sothirak, is do you have thoughts on how to bring greater transparency, greater consultation with the international community as the COC talks go on, given that the interests of third parties are at stake?
Okay, and one more question. We have 6 minutes left, so yes.
I have a question to the Vietnam commander. Vietnam has repeatedly conducted the oil exploration operations in the Vanguard Bank. While these unilateral operations will absolutely raise the tensions between China and Vietnam, so since they have their own claims. So under this condition, in order to maintain the regional stability, will Vietnam stop these unilateral activities in the disputed areas? Thank you.
That was to General Dom. Okay, well, would you care to address that very
quickly? Trước đó thì có một cái câu hỏi của một cái thính giả là cái khuôn khổ hợp tác và cái khả năng nào để thiết lập được cái cơ chế bảo vệ nguồn cá, bảo vệ môi trường và sinh thái biển. Thì trả lời câu hỏi này, tôi cho rằng là cái hợp tác để mà thiết lập một cơ chế bảo vệ nguồn cá hay là bảo vệ môi trường sinh thái biển thì đây là một cái đề xuất mà chúng tôi cho rằng cần phải hợp tác để chúng ta như là một cái giải pháp để chúng ta kiềm chế khủng hoảng. Bởi vì vấn đề môi trường biển hay là vấn đề sinh thái biển thì các quốc gia ven biển đều có trách nhiệm phải bảo vệ. Còn vấn đề nguồn lợi bảo vệ nguồn cá thì các bạn cũng biết là gần đây Việt Nam có rất nhiều cái điều chỉnh về luật cá để bảo vệ nguồn lợi cá. Tuy nhiên cái vấn đề nghề cá ở Biển Đông ấy, thì nó liên quan đến đánh cá truyền thống, liên quan đến ngư trường, liên quan đến tính di cư. Cho nên là cái việc mà cái khả năng nào để thiết lập được cơ chế bảo vệ, tôi cho rằng là vẫn là có khả năng và cũng là một vấn đề các quốc gia. Nhưng mà chúng ta cũng nên tính lại là những cái đề xuất của chúng ta đấy, để kênh 2 này chuyển đến kênh 1 ấy, thì cũng phải có thời gian và đó là sự quan tâm của kênh 1. Đấy là vấn đề đáng quan tâm. Còn vấn đề câu hỏi liên quan đến khai thác dầu khí thì Việt Nam đã khai thác và đang khai thác dầu khí ở những cái nơi mà Việt Nam có chủ quyền hoặc là quyền chủ quyền của mình, và Việt Nam không mở rộng những cái khai thác của mình ra ngoài những cái phạm vi mà Công ước Luật Biển cho phép và Luật Biển Việt Nam đã công bố. Do vậy mà Việt Nam vẫn nghĩ rằng thì là Việt Nam có quyền khai thác ở những cái vùng biển mà mình có quyền chủ quyền của mình. Còn có chồng lấn với Trung Quốc hay đòi hỏi của Trung Quốc hay không thì chúng ta đều biết là những cái yêu sách của Trung Quốc là rất là rộng lớn. Nó không phải là chỉ có liên quan đến Việt Nam về vấn đề dầu khí, với Philippines rồi với nhiều quốc gia khác. Cho nên ở đây là vấn đề lớn mà như tôi nói là một trong cái việc mà xây dựng lòng tin ấy, thì những quốc gia nào mà đòi hỏi có tính độc đoán thì phải tự điều chỉnh cái đòi hỏi của mình, thì cái lòng tin ấy nó sẽ được nhân lên, và và như vậy ấy, thì cái ổn định Biển Đông nó sẽ tốt hơn. Tôi xin hết câu hỏi đấy.
Thank you. I will just ask our organizers, if we go 3 minutes over, are we okay as far as the lunch break and everything? Because it will be hard to end this elegantly in 2 minutes, but in 5 I think we'll be fine. So is that okay if we go over 3 minutes? Thank you. This raises one of the questions. The topic that we have for session 6 is confidence building, preventative diplomacy, and dispute resolution. And one thing I would just note before we end is that the third piece of that, dispute resolution, we really haven't discussed much in this conference. And I think it's just important to remember that these disputes, territorial and maritime disputes, are very, very difficult. And they relate to one another. But I think it would be wrong for us not to also remember that one approach is to try to ultimately narrow and, with any luck, resolve the disputes that are there. So I would just note that is one of the pieces of the topic. We haven't had much of a chance to talk about it, but that it is something that we shouldn't necessarily just assume that these disputes are intractable and cannot be resolved or refined in any way. So I would just note that that's an important part of the topic and something for us not to lose sight of. As much as important as these interim measures are, they're not necessarily a substitute for finding, if possible, some solution to the underlying problems, as difficult as those might be. So why don't we move from beginning to end and answer those questions which are left for us.
Okay, I'm going to address two. How to increase the transparency of the China-ASEAN negotiations. I think institutionalize it as an agenda on the ASEAN +1 meetings, where the ASEAN side explains to their dialogue partners, each one, the status of, and they exchange ideas and views on that. Because I think third parties need to be brought in at the very end of this process formally, but they should be there to see where it's going. There was a question over here about cooperation between ASEAN countries, but I would say there's a model. The ASEAN defense ministers have just reached an agreement for air and coast guard cooperation. And one way of approaching is for ASEAN to have a consensus on issues like that, and then invite all their dialogue partners to support it. So instead of trying, if you can't get a confidence building measure with China, you could then get your own ASEAN consensus to do something. And have the ADMM already approve these sorts of things is a major step forward, because then all the parties that work with ASEAN either have to take that into account or stand outside.
So also answering the question of the gentleman on the right, short answer, the Philippines is currently not considering or exploring possible joint development agreements with other claimant states apart from China. And I also certainly have no authority to speak for my other co-ASEAN countries. But it's important to note that historically there have been instances when there have been joint development agreements between other ASEAN nations, Vietnam, Malaysia, Thailand come to mind, but not strictly speaking, not necessarily with respect to their claims in the South China Sea. What's important to note with respect to that is that it means that the door is not closed to future cooperative arrangements in that regard, because it has been done before. Possibly it can be done again. But what I want to emphasize further is that in the first place, joint development is not the first choice for for confidence building. If you notice, if you go through the single draft negotiating text, nowhere there is joint development mentioned as a possible form of cooperative activity. This is precisely to underline the fact that it's not considered low-hanging fruit in terms of cooperation. There are far simpler ways to build confidence, and inherently in any JDA, there are many aspects that can be sticking points and can cause further tensions. But if thrown in that situation as the Philippines is, well, then we have to work with that. But insofar as the plans, no further plans.
And the last word for Sothirak.
Thank you. 2 points. Very important, Dr. Hai, about not only about stability and peace in the region that ASEAN aspires, it's also to protect the interests of an individual state. ASEAN need to do that. This is a problem. And I can give you a very concrete example. When Vietnam was the chair of ASEAN in 2011 or 10, I think 10, Prime Minister Hun Sen asked your chairmanship to put on the agenda at the summit the dispute between Thailand and Cambodia. Vietnam kindly tell Cambodia, no, cannot, because this is bilateral. And you know, this is a problem. I agree with you, but that's why if you hear what I try to say, we have problem. ASEAN have problem, and don't shy away with this problem. ASEAN never able to discuss seriously hard security issues. South China Sea issues, same thing, but not only the case of non-issuance of a joint communique. You need to look at the PCA also. Everybody go in its own separate way. And that leads to my second point about third-party involvement. Everybody said it's because China tells small state not to do anything. Maybe there is some truth to it, but it's also about ASEAN unity, about ASEAN centrality. The leader need to define it. Are we going to take it? And that's why I said, even when you referred the dispute settlement to the High Council, never, you put it there, but never enacted. To me, when you write something down in terms of a legal statement and you never apply, better take it off. Otherwise, you're relevant being confronted all the time. So I think unless ASEAN leaders are able to really together and say, well, this is the next 50 years we're going to do, we cannot do the, the huge, the same thing again. And that's which Chairman was saying, that to me it is important, as long as there's no solution to the hard security issues that is now confronting the region, ASEAN mechanism still valid, but we have not used it to its own potential. Thank you.
And I'd like to thank this panel for their thoughts and for a lively conversation.